Good evening. Good evening. Hi, it is me, Tracy B, coming to you through the Facebook group, the Pro Se Divorce and Custody Support Group, Information Group, Advisory Group, all of the above. Anyway, it is Thursday. Today is my weekly live where I go live and I discuss a topic that is relevant to family court, specifically divorce and or custody. And sometimes I throw a little bit of child support in there. But I am here tonight to discuss things to expect when you are going through a family court process. And so I've broken it down into three categories. One, what to expect from your court and or judge. Two, what to expect from the process, the court process itself. And three, what to expect from lawyers, whether that be your lawyer, the other party's lawyer, guardian ad litem, who's the lawyer for the child or the children, any of the above. So I chose to do this topic today because it comes up a lot. Questions about whether or not a lawyer is acting ethically, whether or not a judge is being biased, and if they're following a certain procedure, whether or not you could avoid or bypass mediation, all of those things. All of those things come up quite often. I mean, all day long. And so I decided to do this video, tonight's live on this topics to help answer some of those questions. So I had a slideshow, but I don't know how to use it on here. Well, it's not that I don't know how to use it. I didn't have time to set it up so that you guys can see it. So getting through the family court process requires an understanding of everything, right? You can understand the law, or you can know the law, or you can find out where to read the law. But it's not family court, as you should know by now. It's not just about understanding law. It's about understanding the process. It's about understanding the procedure. It's about understanding the role that each player plays. It's about understanding how one thing affects another. It's about understanding. And it's about not just understanding, it's about actually learning how to apply or integrate all of what you know. Or it's overwhelming. I will say that it's definitely overwhelming, but it's necessary if you're actually in the process already. So there's, it's unavoidable. So let's start with the court and or the judge. So the court, what you should expect from the court itself is, first of all, let me just say this, and I say this to every single person. When you are starting out in family court, you need to familiarize yourself with your state's court's website. You need to understand that every single state has a website and every single court is on the website. The information about where they're located, filing fees, filing procedure, a lot of information is on there. Some of them are a little bit more in depth than others, but every single state in this country has a court website set up for their court, and you should always go there. If nothing else, you should go there just to get comfortable and familiar with who's who, what's what, and the how to some degree. Always should be your starting point. And it answers a lot of questions that you have. You should understand that finding information starts there. Finding information, finding answers starts there, not on in Google or in Reddit groups or Facebook groups. It starts there. That's where you should start always. You're going to find out how to file, what to file, when to file it. You're going to find out how you might have access to your case, the court's calendar, the court's location, the court's method of doing things, the court's structure. What I mean by structure, some places have their family court in a district court. Some have them in a civil court. Some have them as a standalone court. You need to know that. You need to have an understanding of that. You need to know how they do their calendars. You need to know how to access the calendars. You need to know how they disseminate that information so that if you need to know that and the other party or the judge or your lawyer doesn't disclose that to you, you know how to find it on your own. You need to know how the court itself is structured as far as the staff and the personnel is concerned. You need to know the departments within the court. Some places have, for instance, they you can get your transcript directly from the court. You go through the court, and then some places have it where you get your transcript from. You go directly to the court reporter or the transcriber. You need to know that, and that you need to know how the court is run because again, a lot of the questions that you're going to have, they can definitely be answered by going to the court and just spending some time familiarizing yourself with what's on the court's website. And then we get to the judge. The judge, you can expect the judge, their credentials are going to be on the court's website. What do I mean by credentials? In family court, there are some elected judges who actually overseeing your case. And then there are what's called magistrates or hearing officers or commissioners that hear your case. In most instances, they don't have equal status of an actual elected judge in most instances. And what that means is that a lot of times they have to get your permission. A lot of times you're not even aware of the fact that you're giving them permission to hear your case when you don't have to. Most courts where the judge is not an actual judge and it's someone else hearing your case, most courts have it where you have to give consent to allow that person to hear your case. And you need to know that because if you consent, what does that mean? Are you giving up your right to certain allowances that an actual judge would grant you? Or what's the procedure if you don't agree with the person, that whoever that person is? What is the procedure if you don't agree with what their ruling is? As opposed to what do you do when it's an actual judge? So you need to know. You need to know who your judge is. You need to know what their credentials are. You also need to know what their caseload is like. A lot of I haven't gone on to all 50 states in a minute, but I've been going on to quite a few states, and a lot of courts have their judges' caseload accessible to the public. What does that mean for you? That means that if you can get an idea of what your judge's caseload is like, or you can compare it to other judges, whether it be in your jurisdiction or not, you can get a sense of what kind of effort they put into their work, into their cases, into their decisions and rulings. You can get an idea of how fast yours is going to move along. You can get an idea of who is, the usual suspects in that specific judge's caseload, meaning the lawyers, the GALs, and et cetera, et cetera. Most, I refrain from saying most, but a lot of courts have that information on the court's website. If you can find your judge, so a lot of times you can find their caseload or you can find their calendar. So if they don't have their caseload per se, you can go in and check their daily calendar and get an idea of which days are days for, 30 cases as opposed to the days that it usually have 10 cases. Believe it or not, judges do that. Judges set it up where a lot of judges will set it up where on Fridays they might have, especially during the summer, they may have, a 10 caseload a day as opposed to Monday or Tuesday where they might have 30 or 50 cases. So if you can get an idea of that for your specific judge, then you can get some idea of, how your case is going to move along, how decisions are going to be made, which day your case is likely to be heard for whatever reason. Like I said, the usual suspects, meaning the lawyers that typically show up before a particular judge and those kind of things. The other thing you would need to, you can expect from judges is their authority, their jurisdiction. Some judges have the authority to hear custody visitation, but they don't have the authority to hear, and I'm going to use judges interchangeably with magistrates and support hearing officers and the like. Some of them have the authority to hear whatever your case entails, meaning it can be an order of protection, or a restraining order or DVO, in addition to a custody visitation, in addition to child support, in addition to the support. It could be a variation of any of those four. It could be the judge might have the authority or the jurisdiction to hear all of those, some of those, one of those, or there may be circumstances where, if the judge that was initially assigned to your case, because there weren't those issues, the judge has to be changed, because now they have to, all of those cases have to be brought before a different judge because that judge didn't have the authority. You also want to know the tenure of a judge. Absolutely want to know the tenure of a judge. If a judge has been sitting on the bench for, if the judge has been sitting on the bench for, 10 years, not just the bench, the family court bench for 10 years, and they're superior, or what is it called? Supervising judge or something like that, or a judge with seniority, you want to know that. You'd want to know that because if your case is brought before that judge and you ever thought about asking that judge recuse themselves or asking that judge be recused, the chances of you getting that judge recused are probably going to be a little slimmer than getting a judge who's only been on the bench for a couple of years and who's not that's tenured or has seniority or is a supervising judge or the like. Believe it or not, those things influence the outcome of your case because, they're human too. And when they know that they have a little bit more seniority or a little bit more tenure, they're going to look at your case or handle your case a little differently. The other thing you want to know about your judge, you would like to know how active they are within the bar community, within the legal community. You should want to know that because you'll want to know how they're perceived, how they're viewed, how they're how credible the other legal community think they are, how a lot of times that can determine how biased they can be or how unfair they could be. All of those things can normally be discerned from finding out their affiliations or associations within the legal community and outside of the legal community as well. But I don't know how much you're going to be able to find that out because a lot of judges keep their private lives private. But within the legal community, you can find out where a judge used to work or which bar associations they are active in, or if they're heading a bar committee or which committee they're involved in or things like that. You can pretty much get an idea of that. That's usually public information. And then we're going to talk about the process and what you can expect from the process. So the process, when I say the process, I mean the actual step-by-step process, the actual method by which a case proceeds through family court. And that is, first of all, the overall process. The overall process means everything that you need to do before you even start the case, before you file a case. That means things like venue, choosing the venue. What that means is, do you file in the county you're in, or do you file in the county that the child is in, or do you file in the county that the other parent is in? Do you base it on residence? Do you base it on proximity? Do you base it on that sort of thing? And that's going to be determined by your court rules. Overall process also has to do with filing. Do you have the authority or the standing to file? If you're in, for instance, if you're a non-family, a non-bio parent, and you're just a family member or a kinship, can you file for custody or visitation? And then you want to know if there are fees. What are the filing fees? Are there waivers for the filing fees? Can you waive the filing fees? What's the method of filing? Can you e-file, or do you have to actually physically drop the papers off, or can you mail them? And then you want to know what the process is for service of process. And service of process means, how do you serve the other party or the other parties? Do you serve them yourself? Does the court serve them? Do you have to hire a sheriff, or do you have to hire a private process server? Again, that's the court. The court usually determines that. There's usually rules that determine how you get that done. And then how is your case assigned? Is it random, like a wheel? Is it all judges with the last name from A to D get all custody visitations that are filed on Monday? You know what I'm saying? I'm being a little facetious, but you get what I mean. What's the process for having to sign? You want to know that too. It would help you to know that, because you can time when you file. It might help you know that to time your filing so that you can get a judge that you know might be a little bit more favorable to exactly the outcome that you're looking for. Right? That would definitely be helpful. You'd want to know if there's is mediation a part of the process. Is parenting education part of? There's some states where you have to do parent education before you could actually even get before a judge. There's some places where you have to do mediation before you get before a judge. There's some places where you have to submit a parenting plan with your petition. You want to know that. You want to know that. You need to know that. Where you're going to find all this stuff? On the court's website. If it's not obvious, just most of them that I've visited all 50 states' websites since I've been doing this, and some I don't remember because some I don't work with clients in those states, but for the most part, I remember every one of them having a search feature. Please familiarize yourself with that. You can just type it in the search feature. Court rules for service of process, court rules for submitting evidence, court rules for filing petition, filing motions, or whatever it is you're looking for. If it's not obviously in a subheading or subdirectory, then use the search feature. And then the process includes what happens in court. Once your case is actually in court, what happens? Are your hearings virtual or in person, or a variation of two? Are there status hearings or status conferences that are done on Zoom, and in the actual hearings and trials are in person, or vice versa, or like I said, a combination of that? You want to know about appearances. Are there any exceptions or allowances where you can actually say, I don't want to have to show up in court if it's a physical appearance. I don't have the time to take off from work. What's the process for that? Or if you want to know if you are represented by an attorney, or if the other party is represented by an attorney, does the court have to be made aware of that? And how is the other party made aware of that? If you're pro se, do you have to inform the court that you're pro se? And do you have to inform the other party's lawyer that you're pro se, or the other party that you're pro se, or anybody else that you're pro se? And how is that? How do you do that? How do you inform the court of that? What the way the court communicates with you. I was talking to someone else a few weeks ago or last week, and she was telling me that the court does not send out court dates, that it's their responsibility to find out. She's pro se, find out on their own what the actual court dates are, which is insane. But you want to know that. And that's another reason why you want to go to the court's website. You go to the court's website, you'll get an idea of if you can create an account on there. Some states have really, really, like New York has a really, really good system of, when you could go in. I think Washington State does too, where you can go in and just see what's happened in your case in the past. I think Ohio does too. What's happened to your case in the past, documents that were submitted, upcoming court dates, whether or not a party was served, whether it's some states really are detailed where you have access to that information. Some are really bad at that. Like I think Tennessee didn't have that. I don't think South Carolina has that, but it depends. You'll know because you'll go in. If court's website usually in .gov, that's how you'll know you're actually on the court's website. It'll say .gov. No, I haven't found anyone that says .com. They're all .gov. I think that's actually a rule or law or something. I don't know. You want to know what the process is for getting other experts involved, or getting a GAL involved, or requesting a custody evaluator, or requesting services like mental health evaluation or drug screening, or anger management or domestic violence. You want to know what the process is for requesting that stuff and having the judge order that or direct that or incorporating that into an order. You want to know what the procedure is for getting a temporary order while the case is going on. You want to know what the procedure is for when there's violations of a temporary order, if there's a way that you could actually get a parent coordinator involved or a mediator involved, or if the court has a system where there's somebody on staff where you can contact them directly and maybe reach out to the other side and be a mediator or some sort of intermediary until the next court date. You want to know that. And again, you'll know that by going to the court's website and putting in that stuff, just putting it in the search bar, and you'll find out if that's what the case is. But those are some of the things that you want to consider that you should keep in mind. And the sooner you acquaint yourself and familiarize yourself with that, the better it will be for you. You want to know what the procedure is for ex parte communication with the court. Some judges, ethically speaking, they're not allowed to have actual conversations off the record with one side without the other side or their attorney being present. But there's some instances where they'll accept like a letter or an email, and then they'll share it with the other side, but you want to know that, because I've seen cases where some litigants have said to me that the judge told them that they can email them or some other form of communication with them, and whatever the judge did with it, the judge did with it. But there's a lot of courts where that's not allowed at all. There's no access to the judge or the judge's assistant or clerk or a court attorney or principal attorney or whatever. But so you'd want to know that. That would help you to know, because your case is going to go on for a long time. And there's going to be some non-compliance. There's going to be a lot of non-compliance. And sometimes it's intentional and sometimes it's not. But you want to know what you can do in the interim. You want to know, especially when there's a temporary order, you want to know what can be done in the interim. And sometimes there's parent coordinators that the court that's on staff in the court that help out, or friends of the court or something like that. It depends. I think Michigan has a friends of the court system that does something like that. You want to know if all court appearances or some court appearances are actually being recorded. You want to know that, because if anything is said on the record in court, that is really a plus for you in the event that you need to bring that up later if you decide to appeal, or if you decide to use that information in some way substantively. So, and I'm hearing lately which is baffling to me, where there's some courts that don't actually record court appearances. And I get status conferences are sometimes not necessarily recorded, because they're usually just something where the court wants to know the status. And they won't allow anything else. So I can understand that. But when you're going in for an update, like for instance, if the judge ordered one or both of the parties to do some drug screening or anger management, something like that, and the judge needs to know that one or both of the parties did not do that, then that should be done on the record, because you might be able to use that later on. So you want that on the record. Something like, oh, we're just checking in, judge, to let you know everything is going smooth. No, that you might not need that on the record. You might not need a recording for that. So you need to know what the procedure is. As an aside, you should always want those things, like I said, that matter. You want those done on the record. But I hear now that there's some courts that don't even do that. They don't record everything, which is insane to me. Everything should be recorded from where I sit anyway, but I get it. You want to know from court who the role players are in the courtroom. This is the process in court. Who are the key players in court? Not just the judge and the lawyer, but who else is there? Is there someone else there and the court reporter? Is there someone else there who serves like as a clerk and I want to tell you why. A lot of times you will hear something the judge said and no one else heard it. No one else heard it. And now you're out of court and you're disagreeing with the other party about what the judge said, because no one else heard it, or it was misunderstood or misinterpreted. If there's someone else in the court, aside from the transcriber or the court reporter, if there's someone else in the court who, like a clerk who's privy to that information, they may be able to help you explain exactly what happened in the court. And whether it be a clerk or the judge's law clerk or the judge's principal attorney or court attorney, whatever it's called, if there's somebody in the court, that's always a good source to find out if they can help you figure out what the judge said, what the judge meant, or to straighten some sort of ambiguity out. That's always super, super duper helpful. And then the process consists of your due process rights. That's where, recordings are necessary or applicable, because you have the right to you have a right to the so many amendments apply in family court: the Fourth Amendment, the 10th Amendment, the Fifth Amendment, the First Amendment. They all, so that's what I mean. That's what 14th Amendment is, what is where your due process rights comes from. But the Bill of Rights is in some shape, form, or fashion applies to you in family court. Yeah, I know. Don't tell me I know. Family court just does away with everybody's rights. I know, I get it. But at the same token, you still want to understand and expect those to have some sort of impact, whether you use that while your case is pending or whether you can bring those up on appeal. You definitely need to know that. And if you don't know that and you find that out later, it might be too late. So know that ahead of time. How will I know that, Tracy? That's a little bit more complicated. You may not know that because I see a lot of people think that because they have rights, that means that it trumps everything else that happens on the state level, and that's not how it works. So you might have to get some sort of consultation from an actual attorney who can explain that to you and help you discern whether or not there's some potential violations or you're vulnerable to some violations in your specific case. But there's always something to actually consider. And then in the court, you want to know, as far as the process is concerned, you want to know if, hold on, I'm trying to get my list up and my phone is dead. This is great. There it is. In the process, inside court, you want to know what the calendar is going to be like, what the procedure is. So for instance, does your court have preliminary conferences, status conferences, pretrial conferences, settlement conferences? You want to know that. You want to know that because that's going to help you. Okay, if you have a temporary order right now, you went to court, you went to your first appearance, you got a temporary order, right? A temporary order is just that, it's temporary. And you want to know if that temporary order is going to be in place until you actually go to trial or something before then. One way to know that is to know or to get an idea of how many times you're going to actually be before the court before the actual trial. How active or involved does the court get between the time that you have your first appearance, your initial appearance, or your preliminary appearance to the actual pretrial, if there is a pretrial? You'd want to know that. You'd want to know if mediation is required. I forgot to mention that earlier in the overall process. You want to know if mediation is required or if it can be waived, or if it's waived, what does that mean? Does that mean that you automatically go to the judge, or does the judge send you to another panel? Or if it's required, does that mean you have to go 3 times or 2 times to satisfy that requirement? Do you want to know if there's fees involved? You want to know who pays those fees? You want to know what happens if those fees aren't paid? Will they delay the process? Will they delay you getting before the judge? Will they just stall the whole court case? All of those things are really, really helpful to know ahead of time. And then lastly, the lawyers, the most fun part of all of this, the lawyers. You have rights when you're represented by an attorney. You have rights when you're a litigant in family court. Those are 2 different things. Your rights as a client of an attorney are different than your rights as a pro se litigant going up against an attorney. And I say that because so many people get that confused. So many people get that confused. Your rights as a client of a lawyer is very different than your rights as a litigant, a pro se litigant against a lawyer. You have rights as a litigant in court. That's different. You have rights as a litigant in court, but you don't necessarily have rights as a pro se litigant against a represented against a lawyer. Those are very different. Your rights as a client, you have the right to have a copy of your retainer agreement, a copy of any sort of rights and responsibilities. Some states make it a requirement that when the lawyer gives you a retainer agreement, they have to include your rights and responsibilities and, and all of that stuff included in the retainer agreement. Some states don't. Either way, you should be made aware of what those are, because every single state follows the ABA model rules when it comes to that. And whether or not they have to actually give you something in writing, they still should explain to you what your rights are as a client, because it doesn't matter. The ABA model rules have been adopted by all 50 states, and they all include, they include how you should be treated, or how you should be, how you should be treated, or the rights you have as a client when you're represented by an attorney. So you should definitely get an agreement, a retainer agreement. That retainer agreement should be explained to you, right? You should never get a retainer agreement shoved in your face and forced to sign within 5 minutes without reading it. You should definitely ask questions. You should definitely make sure some provisions are in the retainer agreement when it comes to fees and how you're going to be billed, and what happens as far as communication is concerned, and what type of representation it's going to cover. All of those things should be explicit in your agreement, in your retainer agreement. You should understand what the communication is like. How do they communicate with you? Is email preferred method? Is it text messages? Is it phone calls? You should understand when is the best time for you to communicate, or for them to communicate. How long of a time period do they respond to your request for information, or phone call, or a visit? You should definitely expect some sort of strategy meeting at some point. You should expect, and personally, I think you should ask for a strategy meeting or whatever periodically, every time something major, not every time something like a motion comes up, but every time something, if it's a motion for something like contempt or an emergency motion, you should maybe talk about, having a meeting about that. But every time something pivotal happens, like depositions, discovery, pre-trial, you should have a meeting. You should have strategy meetings, strategy sessions with your attorney. That's something that a lot of people are not asking for, and you should. And attorneys are not doing that, and you should be asking for that. You should understand that they are supposed to maintain some sort of professionalism with you as a client. That means that they should, talk to you professionally. They should treat you professionally. They should show some courtesy. One of the things I hear a lot of complaining about is that lawyers will take the case, and then every time the court date comes up, there's another lawyer from the office showing up who doesn't know the case. Or that. You should know that. You should be given the courtesy of knowing that. You should be given the courtesy of being brought to speed about, that, and what they've done to bring that lawyer up to speed for your court appearance. You should know that. You should know ahead of time if they're going to ask for a continuance. You should know that. You should not get to court and hear the judge say, "Hey, Ms. Green, where's your attorney?" "Oh, I don't know. I expected him or her to be here." And the judge is like, "You don't know where your attorney is? You should know where your attorney is." Not a good look. You should know that. You deserve that. You should expect that. If there's a conflict of interest, most lawyers have a conflict of interest system, and that's usually dictated by the ethical rules. You should be made aware of that immediately. Immediately, you should be made aware of that. You should know the process for filing complaints against the lawyer. You should understand the process of filing a grievance against the lawyer. A complaint and a grievance and suing them are 3 different things. You can file a complaint against them with the judge. You file a grievance against them with the Bar Association, the grievance committee. And then you can pursue a civil case against them for, return of funds. Those are 3 separate things. Those are your rights as a client when you're represented by an attorney. When you're pro se, though, you don't have rights you have rights, but they don't apply to someone else's lawyer. But the expectations you should expect from the lawyer, the other party's lawyer, the opposing party's lawyer, is professionalism, is courtesy, is honesty, is some level of communication. If they're not comfortable talking to you in person, then talking to you via email or letter. But them saying to you they're not going to talk to you at all because you're pro se, that's unacceptable. And you should make the court aware of that if that's what they do. As a pro se litigant against the lawyer, you should expect them to exchange information, to provide information from you. As a pro se litigant against the lawyer, you should expect them to not abuse the continuances or stall the process or implement or institute frivolous litigation or frivolous motions or frivolous actions. Every single court has the interest of not wasting the court's time. And so that's one obligation that the lawyer has against pro se litigants, is to not do things fraudulently or to misguide you or mislead you. They have to act professional and ethically when it comes to you. And what complaints can you file? Can you file complaints against the opposing party's lawyer? Sure you can. Sure you can. Can you file a grievance against the other party's lawyer? Sure you can. Guess where you're going to find those rules at? Rules for filing a grievance. Yes, go to your court's website, put it in. A lot of times what happens is on the court's website, it might not be on the court's website, but it might send a direct link to where you find that information at. But that's always a great starting point. So in court, the lawyers are supposed to act in good faith with you, with their client, and with the court. Lawyers are always supposed to act in good faith. That means, again, they're supposed to be honest. They're supposed to be professional. They're supposed to not waste the court's time. They're supposed to not do anything that's undermined. Now, let me just say this, though. Just because they're supposed to do this, if they don't, it doesn't mean that they're going to be sanctioned by the disciplinary committee. It doesn't mean that. It just means that you should bring it up to the court and let the court be made aware of that and let the court deal with that. That's what it means. But expecting the court to, dismiss an attorney for that or to actually write up a sanction against them, they're not going to do that. They're not going to do that. But if they are doing something that's unprofessional or it's misguided or misleading or they're withholding information from you and it's unlawful, you should definitely let the judge know that that's what's happening, because the judge may grant you some allowances because of that, or the judge may allow you some courtesies because of that, or the judge might grant you a little bit of favor. It depends. It depends on a lot of other things that are going on, but you should definitely make the court aware of that. Whether or not you should file a grievance against an attorney, though, as a pro se litigant, you definitely need to know what the grievance process is, what constitutes a reason to file a grievance in the first place, because everything is not grievance material, believe it or not. Someone asked me the other day, should they file a grievance against an attorney because they didn't get them the best result, the best outcome possible? That's not their obligation. That's not a grievance. They're only required to represent you and to do what they think is reasonable, provide the most reasonable representation they can. It doesn't mean that they have to go above and beyond. It doesn't mean that they have to bend over backwards. It doesn't mean that they shouldn't try to settle your case. It doesn't mean any of that. It just means that they're supposed to act in good faith and they're supposed to uphold the ethical rules. That's what it means. But even if they don't abide by all the rules, it doesn't mean that it's grievance. It's a reason to file a grievance. The only way you're going to know whether or not it's a reason, if it meets grievance criteria, is by knowing what the grievance rules are. There are rules for grievance. There are grievance rules. Same thing for GALs. The same thing for court evaluators. There are rules. There are rules about how they are recused, how you can get the court to the committee to sanction them. There are rules, but you have to know what those rules are. I think guardian ad litems. I've seen some on some courts websites where the guardian ad litem ethical rules and guidelines are on there as well. I think, was it Florida? It might have been Florida. I think Florida was one state. I think it was Florida. Florida and California have the most information on their websites. They are to me, the most helpful for pro se litigants, hands down. There may be a few more that I won't remember, but I know Florida and California were pretty good. And so, and I think North Carolina had their GAL rules on the website. Some websites actually have instructional videos. That's how intense they are. That's why I'm always telling people when they ask questions, go to your court's website and look to see what's on there, because sometimes you can save yourself so much time and so much money if you go onto the court's website and maybe find out if they have an instructional video and watch the video. That way you can pause it and and rewind it as much as you need to. Lawyers are officers of the court, so they're supposed to act that way. That means they're not supposed to yell and scream and curse at you and and embarrass you and humiliate you, and they're not supposed to represent to the court that they're one way and they're not. I mean, again, that's not necessarily a rule, a reason to file a grievance, but it might be something that the court might decide to act in a different way or address that in a way that might be a little bit more favorable to you and the overall outcome in your case. So just don't overlook that. And I think that is it. That's all I have for now. I'm trying to think if there's anything else. The GAL, what I should have added that. The GAL, what you can expect from the GAL. The GALs in most instances are lawyers. GALs, guardian ad litems, law guardian, attorney for the child, best interest of the child attorney, and there's one other term that's used for them. I'm not talking about the CASA people. I'm talking about the actual lawyers who are in a position to represent the kids. They have rules. They have rules. If they're a lawyer, they have to abide by the ethical rules for lawyers. But then they also have a different set of rules for when they're acting in the capacity of the the attorney for the child or the children. They have rules. Those rules usually cover what to expect from them, which a lot of it overlaps with the rules that they have as an attorney. But they also address, like I said, when they can be replaced or recused or ask for recusal, how they can bill you, when they can bill you, things like that. The same thing with a similar thing with no, not the same thing. Parent coordinators. Some states are really big on parent coordinators, and parent coordinators are usually mental health professionals, or some of them are lawyers. I'm trained as a parent coordinator. Some of them are mediators. Some of them are just parent coordinators. Not to insult them, but some of them are just parent coordinators. And what they are allowed to do and the role that they have and the influence they have in court is going to be determined by your parent coordinator guidelines or rules in your specific jurisdiction. Where you're going to find that? You guessed it. And then there's friends of the court. They're usually similar to parent coordinators. I think there's only a couple of places that actually have friends of the court. And then there's co-parenting therapists. There are what is it called? New Jersey has something else. I'm sorry, I can't remember. But anyone in that capacity, those capacities, the purpose of parent coordinators, friends of the court, they're like an overseer. They're like an intermediary so that you're not getting the court involved as much. Because when you're co-parenting issues never end. And you're not going to take every issue that's, every impasse, every disagreement that you have with your co-parent to the judge. So those people step into that role. It's a little different for a guardian ad litem or law guardian or attorney for the child or best interest of the child attorney. That's a little different because they have more of a role, more of an influential role. And they're not, for the most part, they're not going to serve as an intermediary because that's usually not their job. Their job is to protect the well-being of their clients, which is the child or the children. But the parent coordinators, friend of the court, that's a little different. They're usually like I said, an intermediary, mediator kind of thing. And some of them, or some places, you have to use a parent coordinator. In some places, it's optional, and some places don't even know about parent coordinators. They still haven't implemented it. But I think when I took my parent coordinator train, I think she said there was like maybe 10 or so states that still don't even use parent coordinators, which is shocking. That was last year, though. I don't know if that's changed by now. And then it's custody evaluators. Custody evaluators are usually appointed by the court, and they're not necessarily on the court's panel or anything, but they are. So they're like a list. They're on a list. They're usually on a list, just like forensic psychologists, GALs, mediators. They're usually on a list. So most courts who use these professionals or these experts usually have a process by which these professionals can get on the court's lists. And whatever that process is, they usually have a set of rules that they have to abide by. And so you need to know that. You need to know that. So if you're going to, for instance, ask for a custody evaluator, you want to know what the process is in your jurisdiction for how to get a custody evaluator involved, how they're paid, how you can ask for, them to get their portion of the finances. You need to know, what to expect from them. You need to understand that. You need to understand, because I see so many people think that they should ask for a custody evaluator, and when they find out what exactly the custody evaluator does and how much it costs, and they're blown away. And I'm like, you didn't know that, So, but know that. I'm trying to think if there's anybody else that's a part of the process that I haven't thought of. And DV advocates too are good. DV advocates is different. DV advocates it depends on where you are, because I know for a fact that in New York, there's some agencies that have DV advocates where the court actually respects them and allows them to take an integral part in the case. And then there's some places in New York where they don't, because I know the Bronx, for instance, has they have a couple of organizations that have huge influences in, in family court cases. It depends on what the issues are. If there's DV involved, yes, the DV advocate can usually come in and speak on behalf of the client and, all that sort of thing. Or if it's the abuser in sort of a program, they can come in and speak on behalf of the abuser, whichever the part, what I'm saying? So it depends. But they find it out. How are you going to find that out? Yes, go to your court's website, see if there's a DV section. If not, put it in the search feature, and there you are. Boom, that's it. There's so much more, but that's pretty much it for now. I think I covered the really important stuff. I don't know how to check comments here, though, so I don't know how to do that because I'm streaming it. But anyway, if you have comments, you can definitely leave them on the Facebook Live. Questions, you can leave them on the live, and I'll answer them, because I have to figure out how to do the comments while I'm doing the live. So I appreciate you showing up and watching and listening. Feel free to take advantage of the free 15-minute strategy session that I offer, where I discuss exactly what I can do to help you come up with strategy for your case. You can do that. I think the link is always in the start here or get started pinned post at the top of the group's page. So anyway, thank you so much. Have a good night.